Ayun, hello, magandang gabi sa lahat. At ito nga pala si Lolo Ray at itutuloy natin ang Title 6 of Book 4 ng ating Civil Code of the Philippines. No? Okay, nagtapos tayo sa Article 1544. Ngayon naman, nandito na tayo sa Section 3, yung Conditions and Warranties ng Sale. Dahil ang Title 6 is about sale. So, basahin na natin ang Article 1545. Sabi dito, where the obligation of either party to a contract of sale is subject. Dali lang. Okay. Where the obligation of either party to a contract of sale is subject to any condition which is not performed, such party may refuse to proceed with the contract, or he may waive performance of the condition. Ayan ang sinabi niya. If the other party has promised that the condition should happen or be performed, such first mentioned party may also treat the non-performance of the condition as a breach of warranty. Where the ownership in the thing has not passed, the buyer may treat the fulfillment by the seller of his obligation to deliver the same as described and as warranted expressly or by implication in the contract of sale as a condition of the obligation of the buyer to perform his promise to accept and pay for the thing. Okay. So kung daw merong kondisyon doon sa kontrata ninyo tapos hindi mo ito hindi sinunod ng isa sa isa sa dalawang partidong bahagi ng kontrata, such first mentioned party may also treat the non-performance of the condition as a breach of warranty. Sabi niya naman, where the ownership in the thing has not passed, the buyer may treat the fulfillment by the seller of his obligation to deliver the same as described and as warranted expressly or by implication in the contract of sale as a condition of the obligation of the buyer to perform his promise to accept and pay for the thing. So, yun ang number 1. Di pala siya number 1. Yun ang Article 1545. Okay, Article 1546, any affirmation of fact or any promise by the seller relating to the thing in an express warranty, if the natural tendency of such affirmation or promise is to induce the buyer to purchase the same, and if the buyer purchase the thing relying thereon. No affirmation of the value of the thing, nor any statement purporting to be a statement of the seller's opinion only, shall be construed as a warranty unless the seller made such affirmation or statement as an expert and it was relied upon by the buyer. Diba usually bumibili tayo ng product kasi yung eksperto o yung nagbebenta nun ina-assure niya tayo na maayos yung product na yun at yung assurance na yun minsan ang nagiging sanhi ng ating pagbili ng produkto. Article 1547, in a contract of sale, unless a contrary intention appears, there is, ito raw yung meron sa kontrata ng sale. Number 1, an implied warranty on the part of the seller that he has a right to sell the thing at the time when the ownership is to pass, and that the buyer shall from the time have and enjoy the legal and peaceful possession of the thing. So meron daw implied warranty sa isang kontrata ng sale na kapag binenta ko sa iyo, ito, meron akong karapatang ibenta to, akin ito, hindi ito nakaw, di ba? I have the right to sell this to you, and you as the buyer has the right to enjoy it ng peacefully, di ba? Number 2, an implied warranty that the thing shall be free from any hidden faults or defects, or any charge or encumbrance not declared or known to the buyer. Sabi rito pa, this article shall not, however, be held to render liable a sheriff, auctioneer, mortgagee, pledgee, or other person professing to sell by virtue of authority in fact or law for the sale of a thing in which a third person has a legal or equitable interest. Subsection 1, warranty in case of eviction. Ayun. Kaya nabanggit niya itong mga sheriff, Article 1548, eviction shall take place whenever by a final judgment based on a right prior to the sale or an act imputable to the vendor, the vendee is deprived of the whole or of a part of the thing purchased. The vendor shall answer for the eviction even though nothing has been said in the contract on the subject. The contracting parties, however, may increase, diminish, or suppress this legal obligation of the vendor. Article 1549, the vendee need not appeal from the decision in order that the vendor may become liable for eviction. Kasi 'di ba pagka may eviction, may usapin din ang sale, 'di ba? Kasi pag in-evict ka, paano yung mga gamit mo roon, 'di ba? Usapin palagi sa isang eviction yung sale. O kaya yung nagsanla ka ng bahay, ganyan, in-evict ka. Article 1550, when adverse possession had been commenced before the sale, but the prescription period is completed after the transfer, the vendor shall not be liable for eviction. Para lang malinaw sa ating mga kaalaman, sa ating mga ordinaryong tao, ano ang ibig sabihin ng adverse? Ang ibig sabihin ng adverse ay preventing success or development, harmful or unfavorable. Yun ang ibig sabihin ng adverse. Harmful or hindi unfavorable, sabi. So kapag daw may unfavorable possession has been commenced without the sale but the prescriptive period is completed after the transfer, the vendor, yung nagtitinda, shall not be liable for eviction. Okay. Kasi wala naman sa kanya eh. Magiging ikaw lang liable kung ikaw may possession ng tinitinda mo, di ba? Okay, magtungo tayo sa Article 1551. If the property is sold for non-payment of taxes due and not made known to the vendee before the sale, the vendor is liable for eviction. Article 1552, the judgment debtor. Okay. Judgment debtor, ito yung hinusgahan ng korte na siya yung may utang, is also responsible for eviction in judicial sales unless it is otherwise decreed in the judgment. Okay. Malinaw yon. Pag sinabi sa judgment na hindi siya, edi hindi siya. Ganun lang naman yan eh. Babasahin mo lang yung nakalagay doon sa judgment. Article 1553, any stipulation exempting the vendor from the obligation to answer for eviction shall be void if he acted in bad faith. Yun lang naman yung guiding principle halos sa lahat naman ng usapin. Pag umarte ka ng ang nasa likod ng isip mo ay panggugulang, in bad faith ka, usually your acts are deemed illegal. Kadalasan ganon. Article 1554, if the vendee has renounced the right to warranty in case of eviction and eviction should take place, the vendor shall only pay the value which the thing sold had at the time of the eviction. Should the vendee have made the waiver with knowledge of the risks of eviction and assumed its consequences, the vendor shall not be liable. Bigla man sabihin ito, yung vendee yung bumibili, tinanggap niya, meron siyang kaalaman doon sa risks involved sa kanyang pagbili doon sa vendor. Article 1555, when the warranty has been agreed upon or nothing has been stipulated on this point, in case eviction occurs, the vendee shall have the right to demand of the vendor. Ito yun. Number 1, the return of the value which the thing sold had at the time of the eviction, be it greater or less than the price of the sale. Karapatan ng vendee ito. Number 2, the income of fruits if he has been ordered to deliver them to the party who won the suit against him. Yan, karapatan ng vendee na mag-demand ng ganyan doon sa vendor. Number 3, the costs of the suit which caused the eviction and in a proper case, those of the suit brought against the vendor for the warranty. Number 4, the expenses of the contract if the vendee has paid them. And number 5, the damages and interests and ornamental expenses if the sale was made in bad faith. Article 1556, should the vendee lose by reason of the eviction a part of the thing sold of such importance in relation to the whole that he would not have bought it without said part, he may demand the rescission of the contract, but with the obligation to return the thing without other encumbrances than those which it had when he acquired it, period. Okay. He may exercise this right of action instead of enforcing the vendor's liability for eviction. The same rule shall be observed when two or more things have been jointly sold for a lump sum or for a separate price for each of them, if it should clearly appear that the vendee would not have purchased one without another. Hindi naman bibili nito kung hindi dahil dito. Article 1557, the warranty cannot be enforced until a final judgment has been rendered whereby the vendee loses the thing acquired or a part thereof. Article 1558, ba to? Yun. The vendor shall not be obliged to make good the proper warranty unless he is summoned in the suit for eviction at the instance of the vendee. Article 1559, the defendant vendee shall ask within the time fixed in the rules of court for answering the complaint that the vendor be made a co-defendant. Okay. So sa isang kaso raw na defendant yung bumili, ah dapat lang daw, karapat dapat lang na hilingin niya sa korte na yung pinagbilihan niya ay maging co-defendant. Article 1560, if the immovable sold should be encumbered with any non-apparent burden or servitude not mentioned in the agreement of such nature that it must be presumed that the vendee would not have acquired it had he been aware thereof, he may ask for the rescission of the contract unless he should prefer the appropriate indemnity. So, pwedeng ipa-rescind nung bumili. Nagulat siya, may encumbrance yung binili niya, merong burden yung binili niya. Hindi niya naman ito bibilin kung alam niya lang na may burden ito. So, pwede siyang humiling ng rescission of the contract unless he should prefer, dahil pwede niya ring piliin ang proper indemnity o yung babayaran siya ng daños perjuicios. Neither right can be exercised if the non-apparent burden or servitude is recorded in the registry of property unless there is an express warranty that the thing is free from all burdens and encumbrances. Kasi di ba sinasabi na kung ikaw ay bibili ng isang ari-arian, it is your duty na i-check ito sa registry of property. So hindi mo na pwedeng exercise yung unang right of rescission kung nakasad naman pala ito sa registry of property. Alam mo nang may pabigat doon sa ari-ariang binibili pa rin. Within 1 year to be computed from the execution of the deed, the vendee may bring the action for rescission or sue for damages. 1 year having elapsed, he may only bring an action for damages within an equal period to be counted from the date on which he discovered the burden servitude. Yun yung period. Subsection 2, warranty against hidden defects or of encumbrances upon the thing sold. Article 1561, the vendor shall be responsible for warranty against the hidden defects which the thing sold may have, should they render it unfit for the use for which it is intended, or should they diminish its fitness for such use to such extent that had the vendee been aware thereof, he would not have acquired it or would have given a lower price for it. But said vendor shall not be answerable for patent defects or those which may be visible or for those which are not visible if the vendor profession should have known them. Ganyan eh. Kung kitang-kita naman sa product in defect, kinuha, o kung ikaw naman ay eksperto sa profession na yun, kunwari ikaw bumibili ng motor, kitang-kita mo na yung epekto ng isang kunwari UP sa gas tank, binili mo pa rin. Parang ganun. Article 1562, in a sale of goods, there is an implied warranty or condition as to the quality or fitness of the goods as follows. Number 1, where the buyer expressly or by implication makes known to the seller the particular purpose for which the goods are acquired, and it appears that the buyer relies on the seller's skill or judgment, whether he be the grower or manufacturer or not, there is an implied warranty that the goods shall be reasonably fit for such purpose. Number 2, where the goods are brought by description from a seller who deals in goods of that description, whether he be the grower or manufacturer or not, there is an implied warranty that the goods shall be of merchantable quality. Okay. Yan yung mga implied warranty. Article 1563, in the case of contract of sale of a specified article under its patent or other trade name, There is no warranty as to its fitness for any particular purpose unless there is stipulation or unless meron kayong kasunduan to the contrary. Article 1564, an implied warranty or condition as to the quality or fitness for a particular purpose may be annexed by the usage of trade. Article 1565, in the case of contract of sale by sample, if the seller is a dealer in goods of that kind, there is an implied warranty that the goods shall be free from any defect, rendering them unmerchantable, which would not be apparent on reasonable examination of the sample. Diba? Hindi naman yung reasonable examination ng sample mo, hindi naman makikita ng buyer yung defect, di ba? So, mayroong implied warranty kung nagpapakita ka ng sample ng mga goods mo na maayos naman. So, dapat tong mga Lazada na to, nagte-take note kayo yung mga Shopee di ba? Magpapakita kayong picture, sample, tapos iba yung darating. Maling-mali yun Article 1566, the vendor is responsible to the vendee for any hidden faults or defects in the thing sold even though he was not aware thereof. Kahit hindi ka pa aware, ikaw ang may kasalanan ng vendor. Pero hindi mag-a-apply itong provision na ito. This provision shall not apply if the contrary has been stipulated and the vendor, nung buyer mo na, hindi ko alam, hindi ako aware, may itong problema. Article 1567, sabi niya rito, in the cases of Articles 1561, 1562, 1564, 1565, and 1566, the vendee may elect between withdrawing from the contract and demanding a proportionate reduction of the price with damages in either case. Article 1568, if the thing sold should be lost in consequence of the hidden faults and the vendor was aware of them, he shall bear the loss and shall be obliged to return the price and refund the expenses of the contract with damages. If he was not aware of them, he shall only Article 1569. If the thing sold had any hidden fault at the time of the sale and should thereafter be lost by a fortuitous event or through the fault of the vendee had when it was lost. If the vendor acted in bad faith, he shall pay damages to the vendee. Article 1570, the preceding articles of this subsection shall be applicable to judicial sales, except that the judgment debtor shall not be liable for damages. Article 1571, actions arising from the provisions of the preceding 10 articles shall be barred after 6 months from the delivery of the thing sold. Article 1572, if 2 or more animals are sold together, whether for a lump sum or for a separate price for each of them, the redhibitory defect of one shall only give rise to its redhibition and not that of the others, unless it should appear that the vendee would not have purchased the sound animal or animals without the defective one. The latter case shall be presumed when a team, yoke pair, or set is bought, even if a separate price has been fixed for each one of the animals composing the same. So, meron ako hindi naintindihan doon, yung redhibition. Ano ba ibig sabihin ng redhibition? Redhibition. Ano ibig sabihin nito? Hanapin natin. Sabi rito, the rescission of the sale or of a reduction in the purchase price of a thing that has a redhibitory defect. Okay, yun ang ibig sabihin. The action for such a rescission or reduction. Yun ang ibig sabihin. Okay. Medyo naguluhan pa rin ako, pero parang, ayun. Okay, naintindihan na natin. Yun ang ibig sabihin. So, kung dalawa o higit pa ang hayop na binili mo o yung binenta, tapos yung isa ay may redhibitory defect, yung redhibition na yun shall only be applicable to one, dun sa mayroon lamang depekto. Article 1573. The provisions of the preceding article with respect to the sale of animals shall in like manner be applicable to the sale of other things. Article 1574. There is no warranty against hidden defects of animals sold at fairs or at public auctions or of livestock sold as condemned. Okay? Article 1575. The sale of animals suffering from contagious diseases shall be void or wala itong bisa. A contract of sale of animals shall also be void if the use or service for which they are acquired has been stated in the contract and they are found to be unfit therefore. So, kunwari, namili ako sa iyo ng kalabaw na ang purpose do sa contract of sale natin ay gagamitin ko siya para mag-araro. Siya naman ay pilay o hindi makalakad na kalabaw. Diba? So, that is void. Hindi ko siya magagamit. Article 1576. If the hidden defect of animals, even in case a professional inspection has been made, should be of such a nature that expert knowledge is not sufficient to discover it, the defect shall be considered as redhibitory o yung hinanap natin kanina, ibig sabihin resistible. But if the veterinarian, through ignorance or bad faith, should fail to discover or disclose it, he shall be liable for damages. Kunwari yung veterinarian ay isang kaibigan nung nagbebenta in bad faith, o di ba? Para may kwento lamang ako sa inyo, meron akong motor na pinagawa. Noong araw, big bike siya. Lifan na 150cc lamang pero big bike. Tapos hindi na siya mapaandar, pinapagawa ko. Hindi mapaandar nung gumagawa, may matandang gumagawa, hindi niya naman alam gawin. Tapos may nakasilip doon na kapitbahay siya. May kapitbahay siya, pinasyalan yun, nakita, wow, ganda ng motor. So gustong bilhin, ang sinabi sa kanya nung mekaniko, magagawa pa yan. So ako, dahil nakita kong hindi na maayos yung matandang mekaniko at ayoko na rin ng sakit ng ulo, sabi ko, ibenta ko na rin tong motor na to. Yun nga lang, binarat nila ako. So pumayag na ako. Sige, kesa naman di ko pa kinabangan, mababang halaga ko na lang ibenta. So, akala nilang dalawa, nakagulang sila kasi sila yung dalawa yung nag-usap eh. So, ginastusan na nitong bumili sa akin, yung tropa ng mekaniko, yung motor, pinaganda niya na, hoping siya na andar, hindi umandar. Okay. So, nung hindi ito umandar, hindi niya pwedeng isisi sa akin yun. Kasi yung mekaniko, di man ako mekaniko, yung mekaniko, nag-garantiya siya kanya na, andarin yan, patatagalin ko lang gawin, tapos may inip yung yung nagpapagawa, ibebenta niya na lang sa iyo ng mura. Nakarma sila. Okay. So yun yung ibig sabihin nitong Article 1576 na ito sa hayop. Okay. Article 1577, the redhibitory action based on the faults or defects of animals must be brought within 40 days from the date of their delivery to the vendee. This action can only be exercised with respect to faults and defects which are determined by law or by local customs. Article 1578. If the animal should die within 3 days after its purchase, the vendor shall be liable if the disease which caused the death existed at the time of the contract. Alam mo na may sakit yon, namatay siya within 3 days after the purchase. Kasalanan mo yon. Hindi mo kasalanan yun, syempre, kung namatay siya dahil nasagasaan sa pangasiwa ng vendee. Wala naman kasalanan yung vendor doon. Article 1580, in the sale of animals with redhibitory defects, the vendee shall also enjoy the right mentioned in Article 1567. But he must make use thereof within the same period which has been fixed for the exercise of the redhibitory action. Article 1581, the form of sale of large cattle shall be governed by special law. So meron yatang nakalaang batas dyan na mag-govern doon sa sale ng large cattle. At Chapter 5, obligations of the vendee, o ito yung obligasyon ng bumili. Article 1582, the vendee is bound to accept delivery and to pay the price of the thing sold at the time and place stipulated in the contract. If the time and place should not have been stipulated, the payment must be made at the time and place of the delivery of the thing sold. So kung kunwari kayo ay nag-order sa Lazada, o kayo po ay nag-order ng online, magpapa-deliver kayo ng food, ang isang bumili ay may obligasyon na tanggapin yung in-order mo, di ba? Kasi tandaan nyo, pwede kayong kasuhan ng damages dito. Di ba? Lagi yung tatandaan yan, maaari kayong kasuhan. Or, hindi man kayo kasuhan, pag kinailangan nyo next time nag-order kayo, hindi na kayo tutugunan. Kasi, naka-black ball na kayo dahil kayo ay salbahe. Article 1583, unless otherwise agreed, the buyer of goods is not bound to accept delivery thereof by installments. Okay? Unless na pagkasunduan, sabi, yung bumibili ay hindi obligadong tanggapin ang delivery by installment. Where there is a contract of sale of goods to be delivered by stated installments, which are to be separately paid for, and the seller makes defective deliveries in respect of one or more installments, or the buyer neglects or refuses without just cause to take delivery of or pay for one more installments, it depends in each case on the terms of the contract and the circumstances of the case, whether the breach of contract is so material as to justify the injured party in refusing to proceed further and suing for damages for breach of the entire contract, or whether the breach is severable, giving rise to a claim for compensation, but not to a right to treat the whole contract as broken. So, depende raw yan. Kung kunwari, ang binibili mo, nagkasundo kayo, ang binibili mo, by installment mo rin babayaran, ang binibili mo, pyesa by pyesa, kunwari. So, paano naman kung yung vendor, diniliver niya lang kalahating pyesa nito? Paano mo naman pakikinabangan yung pyesa mo nang wala yung iba? So, hindi talaga maganda yung delivery by installments unless nagkasundo nga kayo, sabi, di ba? Article 1584, where goods are delivered to the buyer which he has not previously examined, he is not deemed to have accepted them unless and until he has had a reasonable opportunity of examining them for the purpose of ascertaining whether they are in conformity with the contract if there is no stipulation to the contrary. Itong provision na to, Article 1584, ay very good ito sa mga yung nag-online shopping. So, pwede nyo munang i-examine bago nyo tanggapin yung goods. Kaya lang, ang hirap nga lang kung electronic goods ang binili ninyo, hindi pa ito na-charge. Paghihintayin mo naman masyado yung rider, kawawa naman. Bago mo siya mabuksan, 30 minutes mo muna isasaksak. So, kawawa din yung rider, di ba? Pero maganda to, i-examine nyo muna yung goods bago nyo tanggapin. Unless otherwise agreed, when the seller tenders delivery of goods to the buyer, he is bound on request to afford the buyer a reasonable opportunity of examining the goods for the purpose of ascertaining whether they are in conformity with the contract. Where goods are delivered to a carrier by the seller in accordance with an order from or agreement with the buyer upon the terms that the goods shall not be delivered by the carrier to the buyer until he has paid the price, whether such terms are indicated by marking the goods with the words collect on delivery, or otherwise the buyer is not entitled to examine the goods before the payment of the price in the absence of agreement or usage of trade permitting such examination. Okay. Article 1585, the buyer is deemed to have accepted the goods when he intimates to the seller that he has accepted them, or when the goods have been delivered to him and he does any act in relation to them which is inconsistent with the ownership of the seller, or when after the lapse of a reasonable time he retains the goods without intimating to the seller that he has rejected them. Hindi niya naman sinabi ni reject niya, so hindi niya pinaalam. So, tinanggap niya yun. Article 1586, in the absence of express or implied agreement of the parties, acceptance of the goods by the buyer shall not discharge the seller from liability and damages or other legal remedy for breach of any promise or warranty in the contract of sale, period. But, if after acceptance of the goods, the buyer fails to give notice to the seller of the breach in any promise of warranty within a reasonable time after the buyer knows or ought to know of such breach. The seller shall not be liable therefore. Okay? Mag-break tayo sandali at ako'y magbabalik din. Pagkalipas lamang ng ilang paalala. Okay po, tayo muli nagbabalik. Nandito na tayo sa Article 1587 ng Title 6 pa rin of the Civil Code, Sales. Sabi rito, unless otherwise agreed, where goods are delivered to the buyer and he refuses to accept them, having the right so to do, he is not bound to return them to the seller, but it is sufficient if he notifies the seller that he refuses to accept them. If he voluntarily constitutes himself a depositary thereof, he shall be liable as such. Article 1588. If there is no stipulation as specified in the first paragraph of Article 1523, when the buyer's refusal to accept goods is without just cause, the title thereto passes to him from the moment they are placed at his disposal. Wala ka namang just cause, wala ka namang dahilan na valid, tumatanggi ka, order ka, di ba? Article 1589, the vendee shall owe interest for the period between the delivery of the thing and the payment of the price in the following three cases. Number 1, should it have been so stipulated? Napag-usapan ito. Number 2, should the thing sold and delivered produce fruits or income? Number 3, should he be in default from the time of judicial or extrajudicial demand for the payment of the price? Article 1590, should the vendee be disturbed in the possession or ownership of the thing acquired, or should he have reasonable grounds to fear such disturbance by a vindicatory action or a foreclosure of mortgage, he may suspend the payment of the price until the vendor has caused the disturbance or danger to cease, unless the latter gives security for the return of the price in a proper case, or it has been stipulated that, notwithstanding any such contingency, the vendee shall be bound to make the payment. A mere act of trespass shall not authorize the suspension of the payment of the price. Article 1591. Should the vendor have reasonable grounds to fear the loss of immovable property sold and its price, he may immediately sue for the rescission of the sale. Should such ground not exist, the provision of Article 1191 shall be observed. Ayun. Article 1592, in the sale of immovable property, even though it may have been stipulated that upon failure to pay the price at the time agreed upon, the rescission of the contract shall of right take place, the vendee o yung bumibili may pay even after the expiration of the period, as long as no demand for rescission of the contract has been made upon him, either judicially or by a notarial act. After the demand, the court may not grant him a new term. Article 1593. With respect to movable property, the rescission of the sale shall of right take place in the interest of the vendor if the vendee, upon the expiration of the period fixed for the delivery of the thing, should not have appeared to receive it, or having appeared, he should not have tendered the price at the same time unless a longer period has been stipulated for its payment. Okay, magtungo na tayo sa Chapter 6, Actions for Breach of Contract of Sale of Goods. Yung kanina pinag-usapan natin, mga rescission, yung naririnig nyo. Ito naman, Actions for Breach of Contract. Ayan. Fina-file din sa korte ito. Breach of Contract. Article 1594, Actions for breach of the contract of sale of goods shall be governed particularly by the provisions of this chapter, and as to matters not specifically provided herein, by other applicable provisions of this title. Article 1595, where under a contract of sale, the ownership of the goods has passed to the buyer, and he wrongfully neglects to or refuses to pay for the goods according to the terms of the contract of sale, the seller may maintain an action against him for the price of the goods. Kasi nga naman, anong lohika nun? May kontrata tayo, contract of sale. Ako yung seller, ikaw yung buyer, nasa iyo na yung binibili mo. Hindi ka nagbayad. O edi, ano nangyari sa meeting of the minds? Di ba, ang usapan natin, ibibigay ko yan sa'yo at babayaran mo ko. Di ba? Where under a contract of sale, the price is payable on a certain day, irrespective of delivery or of transfer of title, and the buyer wrongfully neglects or refuses to pay such price, the seller may maintain an action for the price, although the ownership in the goods has not passed. But it shall be a defense to such an action that the seller at any time before the judgment in such action has manifested an inability to perform the contract of sale on his part, or an intention not to perform it. Although the ownership in the goods has not passed, if they cannot readily be resold for a reasonable price, and if the provisions of Article 1596, fourth paragraph are not applicable, the seller may offer to deliver the goods to the buyer, and if the buyer refuses to receive them, may notify the buyer that the goods are thereafter held by the seller as bailee for the buyer. Thereafter, the seller may treat the goods as the buyer's and may maintain an action for the price. So, yung hindi tinanggap, so thereafter daw, yung hindi tumanggap, yung bumibili, pwede niyang i-notify yung buyer that the goods are thereafter held by the seller as bailee for the buyer. So, yung buyer na yun ang ikaw yung seller, nasa iyo pa rin yung goods, pero ikaw yung bailee, nasa temporary na pangangalaga mo, parang ganun, pero sa buyer na yun, parang ganun. Thereafter, the seller may treat the goods as the buyers, yun na nga, may-ari na nun yung buyer, and may maintain an action for the price. So kung file ka sa korte ng action na, bayaran niya yun. Article 1596, where the buyer wrongfully neglects or refuses to accept and pay for the goods, the seller may maintain an action against him for damages for non-acceptance. The measure of damages is the estimated loss directly and naturally resulting in the ordinary course of events from the buyer's breach of contract. Where there is an available market for the goods in question, the measure of damages is, in the absence of special circumstances showing proximate damage of a different amount, the difference between the contract price and the market or current price at the time or times when the goods ought to have been accepted, or if no time was fixed for acceptance, then at the time of the refusal to accept. If, while labor or expense of material amount is necessary on the part of the seller to enable him to fulfill his obligations under the contract of sale, the buyer repudiates the contract or notifies the seller to proceed no further therewith, the buyer shall be liable to the seller for labor performed or expenses made before receiving notice of the buyer's repudiation or counter demand. The profit the seller would have made if the contract or the sale had been fully performed shall be considered in awarding the damages. Article 1597. Where the goods have not been delivered to the buyer and the buyer has repudiated the contract of sale or has manifested his inability to perform his obligations thereunder or has committed a breach thereof, the seller may totally rescind the contract of sale by giving notice of his election so do to the buyer. Article 1598. Where the seller has broken a contract to deliver specific or certain goods, a court may, on application of the buyer, direct that the contract shall be performed specifically without giving the seller the option of retaining the goods on payment of damages. The judgment or decree may be unconditional or upon such terms and conditions as to damages, payment of the price, and otherwise as the court may deem just. Article 1599. Where there is a breach of warranty by the seller, the buyer may, at his election, ito yun, pwedeng remedyo ng buyer. Number 1, accept or keep the goods and set up against the seller the breach of warranty by way of recoupment in diminution or extinction of the price. Number 2, accept or keep the goods and maintain an action against the seller for damages for the breach of warranty. Number 3, refuse to accept the goods and maintain an action against the seller for damages for the breach of warranty. Number 4, rescind the contract of sale and refuse to receive the goods, or if the goods have already been received, return them or offer to return them to the seller and recover the price or any part thereof which has been paid. When the buyer has claimed and been granted a remedy in any one of these ways, no other remedy can thereafter be granted without prejudice to the provisions of the second paragraph of Article 1191. Where the goods have been delivered to the buyer, he cannot rescind the sale if he knew of the breach of warranty when he accepted the goods without protest, or if he fails to notify the seller within a reasonable time of the election to rescind, or if he fails to return or to offer to return the goods to the seller in substantially as good condition as they were in at the time the ownership was transferred to the buyer. But if deterioration or injury by the goods, ulitin natin, but if deterioration or injury of the goods is due to the breach or warranty, such deterioration or injury shall not prevent the buyer from returning or offering to return the goods to the seller and rescinding the sale. Mapawalang bisa yung sale dahil nasira agad eh. Where the buyer is entitled to rescind the sale and elects to do so, he shall cease to be liable for the price upon returning or offering to return the goods. If the price or any part thereof has already been paid, the seller shall be liable to repay so much thereof as has been paid concurrently with the return of the goods, or immediately after an offer to return the goods in exchange for repayment of the price. Where the buyer is entitled to rescind the sale and elects to do so, if the seller refuses to accept an offer of the buyer to return the goods, the buyer shall thereafter be deemed to hold the goods as bailee for the seller, but subject to a lien or claim to secure payment of any portion of the price which has been paid, and with the remedies for the enforcement of such lien allowed to an unpaid seller by Article 1526. Ang haba, no? And number 5, In the case of breach of warranty of quality, such loss in the absence of special circumstances showing proximate damage of a greater amount is the difference between the value of the goods at the time of delivery to the buyer and the value they would have had if they had answered to the warranty. Okay, yun ang lima. Binasa natin yung lima na where there is a breach of warranty by the seller, the buyer may do so. Itong lima na ito. Chapter 7, Extinguishment of Sale. Article 1600, sales are extinguished by the same causes as all other obligations by those stated in the preceding articles of this title and by conventional or legal redemption. Okay. Doon daw nagtatapos ang sale. Section 1, Conventional Redemption. Article 1601, conventional redemption shall take place when the vendor reserves the right to repurchase the thing sold, with the obligation to comply with the provisions of Article 1616 and other stipulations which may have been agreed upon. Similar to dun sa right to repurchase ng isang natalo, yung narimata ang kanyang pag-aari, meron siyang 1 year redemption period. Similar to sa ganun na bibenta ko sa ito pero naka-reserve sa akin ang karapatan na bilhin ito ulit sa iyo. Kailangan mag-comply ka dun sa usapan nyo at dun sa provision of Article 1616. Article 1602, the contract shall be presumed to be an equitable mortgage in any of the following cases. Okay. Ito yung mga equitable mortgage. Number 1, when the price of a sale with right to repurchase is unusually inadequate. Okay? Hindi sapat. Number 2, when the vendor remains in possession as lessee or otherwise, yung nagbenta, siya pa rin ang may possession dun sa property. Number 3, when upon or after the expiration of the right to repurchase another instrument extending the period of redemption or granting a new period is executed. Number 4, when the purchaser retains for himself a part of the purchase price. Number 5, when the vendor binds himself to pay the taxes of the thing sold. Ayan, pwede niya nga i-repurchase yan. Number 6, and in any other case where it may be fairly inferred that the real intention of the parties is that the transaction shall secure the payment of a debt or the performance of any other obligation. In any of the foregoing cases, any money, fruits, or other benefit to be received by the vendee as rent or otherwise shall be considered as interest, which shall be subject to the usury laws. Okay. Basa na natin yung usury dati, di ba? Article 1603, in a case of doubt, a contract purporting to be a sale with right to repurchase shall be construed as an equitable mortgage. Okay. Isa siyang naayon sa batas na pagsasanla. Article 1604, the provisions of Article 1602 shall also apply to a contract purporting to be an absolute sale. Okay. Article 1605, in the cases referred to in Articles 1602 and 1604, the apparent vendor may ask for the refusion of the instrument. Article 1606, the right referred to in Article 1601, in the absence of an express agreement, shall last 4 years from the date of the contract. Should there be an agreement, the period cannot exceed 10 years. However, the vendor may still exercise the right to repurchase within 30 days from the time final judgment was rendered in a civil action on the basis that the contract was a true sale with right to repurchase. Article 1607. In a case of real property, the consolidation o pagsasama-sama of ownership in the vendee by virtue of the failure of the vendor to comply with the provisions of Article 1616 shall not be recorded in the Registry of Property without a judicial order after the vendor, yung nagtinda, has been duly heard. Diba? Yung right to be heard, sabi nga. Article 1608, the vendor may bring his action against every possessor whose right is derived from the vendee, even if in the second contract No mention should have been made of the right to repurchase without prejudice to the provisions of the mortgage law and the land registration law with respect to third persons. Article 1609. The vendee is subrogated to the vendor's rights and actions. Article 1610. The creditors of the vendor cannot make use of the right of redemption against the vendee until after they have exhausted the property of the vendor. Article 1611. In a sale with a right to repurchase, the vendee of a part of an undivided immovable who acquires the whole thereof in the case of Article 498 may compel the vendor to redeem the whole property if the latter wishes to make use the right of redemption. Ito yung sale with a right of redemption. Akin yung pag-ari, binenta ko sa'yo, pero sa usapan natin, may karapatan akong bilhin ulit yan sa'yo. Article 1612. If several persons jointly and in the same contract should sell an undivided immovable with the right of repurchase, none of them may exercise this right for more than his respective share. Naayon lang dun sa share niya. The same rule shall apply if the person who sold an immovable alone has left several heirs, in which case each of the latter may only redeem the part which he may have acquired. Article 1613. In the case of the preceding article, the vendee may demand of all the vendors or co-heirs, mga tagapagmana, that they come to an agreement upon the purchase of the whole thing sold. And should they fail to do so, the vendee cannot be compelled o yung bumili cannot be compelled to consent o pumayag to a partial redemption. Article 1614. Each one of the co-owners of an undivided immovable who may have sold his share separately may independently exercise the right of repurchase as regards his own share, and the vendee cannot compel him to redeem the whole property. Article 1615. If the vendee should leave several heirs, the action for redemption cannot be brought against each of them except for his own share, whether the thing be undivided or it has been partitioned among them. But if the inheritance has been divided and the thing sold has been awarded to one of the heirs, the action for redemption may be instituted against him for the whole. Article 1616. The vendor cannot avail himself of the right of repurchase without returning to the vendee the price of the sale, and in addition, number 1, the expenses of the contract and any other legitimate payments made by the reason of sale. Number 2, the necessary and useful expenses made on the thing sold. Article 1617. At the time of the execution of the sale, there should be on the land visible or growing fruits. There shall be no reimbursement for or prorating of those existing at the time of redemption if no indemnity was paid by the purchaser when the sale was executed. Should there have been no fruits at the time of the sale and some exist at the time of redemption, they shall be prorated, hati sila, between the redemptioner and the vendee, giving the latter the part corresponding to the time he possessed the land in the last year, counted from the anniversary of the date of the sale. Hati na lang kayo, binenta ko sa'yo, walang puno yan. Nung i-redeem ko na may puno na, di hati tayo. Prorata with respect to the share, di ba? Article 1618. The vendor who recovers the thing sold shall receive it free from all charges or mortgages constituted by the vendee, but he shall respect the leases which the latter may have executed in good faith and in accordance with the custom of the place where the land is situated. Okay, dapat ni-recover ko yung thing sa'yo. 'Di ba may right to repurchase yung transaction nating dalawa. Ni-recover ko sa'yo yung bag, yung lote ko kunwari. Dapat wala namang, hindi mo naman dapat sinanla. Pero pwede kong respetuhin yung mga pinapaupahan mo. O sa akin na sila magbabayad ng upa. 'Di ba? Section 2, legal redemption. Legal na pagbabawi. Article 1619. Legal redemption is the right to be subrogated upon the same terms and conditions stipulated in the contract in the place of one who acquires a thing by purchase or dacion in payment or by any other transaction whereby ownership is transmitted by onerous title. Ibig sabihin nun, mayroong right to repurchase. Article 1620, a co-owner of a thing may exercise the right of redemption in case the shares of all of them, in case the shares of all the other co-owners or of any of them are sold to a third person. If the price of the alienation is grossly excessive, the redemptioneer shall pay only a reasonable one. Should two or more co-owners desire to exercise the right of redemption, they may only do so in proportion to the share they may respectively have in the thing owned in common. Siyempre, doon lang sa share mo, Article 1621. The owners of adjoining land shall also have the right of redemption when a piece of rural land, the area of which does not exceed 1 hectare, is alienated unless the grantee does not own any rural land. This right is not applicable to adjacent lands which are separated by brooks, drains, ravines, roads, and other apparent servitudes for the benefit of other estates. If two or more adjoining owners desire to exercise the right of redemption at the same time, the owner of the adjoining land of smaller areas shall be preferred. And should both lands have the same area, the one who first requested the redemption. Article 1622. Whenever a piece of urban land which is so small and so situated that a major portion thereof cannot be used for any practical purpose without a reasonable time having been bought merely for speculation, is about to be sold, the owner of any adjoining land has a right of preemption at a reasonable price. If the resale has been perfected, the owner of the adjoining land shall have a right of redemption also at a reasonable price. Okay. Yung katabing lupa, meron siyang may karapatan siyang bumili. When two or more owners of adjoining lands wish to exercise the right of preemption or redemption, dalawa kasi ang preemption. Ayaw mo sana mapunta yung katabi mong lote sa iba, sa'yo na lang. Or redemption, the owner whose intended use of the land in question appears best justified shall be preferred. Article 1623, the right of legal preemption or redemption shall not be exercised except within 30 days from the notice in writing by the prospective vendor or by the vendor as the case may be. Tama nga yung tatay ko. Kailangan mong bigyan ng notice sila. The deed of sale shall not be recorded in the registry of property unless accompanied by an affidavit of the vendor that he has given written notice thereof to all possible redemptioneers. Diba? Yung kapitbahay mo, yung may-ari ng katabi mong lote, ayun, kailangan i-notify mo sila. The right of redemption of co-owners excludes that of adjoining owners. Okay. So malinaw dito, hindi pala nagkamali pala ako kasi sabi niya the right of redemption of co-owners excludes o hindi sinasabi yung mga katabing owners. Yung mga kasama mo lang na owners, kailangan mo silang i-notify na gusto mong i-avail yung right of preemption or right of redemption mo. Usually this applies to a land owned in common. Common kayo magkakapatid na may-ari. Chapter 8, Assignment of Credits and Other Incorporeal Rights. Nalaman na natin yung incorporeal rights. Ang halimbawa niya na yung stock, pagmamayari ng stock, di ba? Article 1624, an assignment of creditors and other incorporeal rights shall be perfected in accordance with the provisions of Article 1475. Article 1625, an assignment of a credit, right or action shall produce no effect as against third person unless it appears in a public instrument or the instrument is recorded in the registry of property in case the assignment involves real property. Yung sinasabi niya lagi dito na registry of property, yan na siguro kung di ako nagkakamali, yung registry of deeds sa ngayon. Okay, ano ba yan? Saan na ako nawala? Article 16 teka lang, nawala. Ano ba yan? Napindot ko. Registry of Property. Hanapin natin ulit. Napindot ko eh. Mariosep. Ayun, okay. Article 1626. The debtor who, before having knowledge of the assignment, pays his creditor shall be released from the obligation. Siyempre, nagbayad ka na ng utang mo, di wala ka ng obligasyon. Article 1627, the assignment of a credit includes all the accessory rights such as a guarantee, mortgage, pledge, or preference. No, kasali daw yun pag inassign mo yung utang, no? Includes all the accessory rights, guarantee, mortgage, pledge, or preference. Article 1628, the vendor in good faith, yung nagbebenta in good faith, shall be responsible for the existence and legality of the credit at the time of the sale, unless it should have been sold as doubtful, but not for the solvency of the debtor, unless it has been so expressly stipulated, or unless the insolvency was prior to the sale and of common knowledge. Even in these cases, he shall only be liable for the price received and for the expenses specified in number 1 of Article 1616. The vendor in bad faith shall always be answerable for the payment of all expenses and for damages. Pag bad faith ka, ikaw may kasalanan. Ikaw magbabayad. Article 1629, in case the assigner in good faith should have made himself responsible for the solvency of the debtor and the contracting party should not have agreed upon the duration of the liability, it shall last for 1 year only from the time of the assignment if the period had already expired. If the credit should be payable within a term or period which has not yet expired, the liability shall cease 1 year after the maturity. Article 1630, one who sells an inheritance without enumerating the things of which it is composed shall only be answerable for his character as an heir. Article 1631, one who sells for a lump sum the whole of certain rights, rents, or products shall comply by answering for the legitimacy of the whole in general, but he shall not be obliged to warrant each of the various parts of which it may be composed, except in the case of eviction from the whole or the part of greater value. Article 1632, should the vendor have profited by some of the fruits or received anything from the inheritance sold, he shall pay the vendee thereof if the contrary has not been stipulated. Kung yun daw ang titinda daw ay kumita dahil doon sa mga fruits na kanyang natanggap na hindi naman niya mana, he shall pay the vendee if the contrary has not been stipulated. Article 163, the vendee, o yung bumibili on his part, the vendee shall reimburse the vendor for all that the latter may have paid for the debts and of charges on the estate and satisfy the credits he may have against the same unless there is an agreement to the contrary. Article 1634, when a credit or other incorporeal right in litigation is sold, na ibenta na yon, the debtor shall have a right to extinguish it by reimbursing the assignee for the price the latter paid, therefore, the judicial costs incurred by him and the interest on the price from the day on which the same was paid. A credit or other incorporeal right shall be considered in litigation from the time the complaint concerning the same is answered. The debtor may exercise his right within 30 days from the date the assignee demands payment from him. Article 1635, from the provisions of the preceding article shall be excepted the assignments or sales made, number 1, to a co-heir or co-owner of the right assigned, number 2, to a creditor in payment of his credit, and number 3, to the possessor of a tenement or piece of land which is subject to the right in litigation assigned. Okay. Chapter 9, General Provisions. Article 1636, in the preceding articles in this title governing the sale of goods, unless the context or subject matter otherwise requires, number 1, document of title to goods includes any bill of lading, dock warrant, kedan or warehouse receipt, or order for the delivery of goods, or any other document used in the ordinary course of business in the sale or transfer of goods as proof of the possession or control of the goods, or authorizing or purporting to authorize a possessor of the document to transfer or receive, either by endorsement or by delivery, goods represented by such document. Goods includes all chattels, personal but not things in action for money of legal tender in the Philippines. Alamin natin mga kalayman kung ano ibig sabihin ng chattel para sure. Alam ko ito yung mga kuan eh. Ang pagkakaintindi ko dito mga cattle eh. Shuttle, cattle. Hindi pala. Ito yung, ang alam ko basta kinakalakal ng mga ano. Ano ibig sabihin nito? Okay. An item of tangible, movable, tangible na hawakan, movable, or immovable property except real estate, hindi daw kasama yan, and things such as buildings, hindi siya connected, hindi siya kasama. Connected siya with real property. Yun ang ibig sabihin ng shuttle. Tangible, movable property. Except real property and buildings. Yun ang shuttle, okay? Okay, saan ako? Goods includes all chattels, personal but not things in action or money of legal tender in the Philippines. The term includes growing fruits or crops. Kasi nakadikit yun sa real estate eh. Order relating to documents of title means an order by endorsement on the documents. Quality of goods includes their state or condition. Specific goods means goods identified and agreed upon at the time a contract of sale is made. An antecedent or pre-existing claim, whether for money or not, constitutes value where goods or documents of title are taken either in satisfaction thereof or as security therefore. Okay? Ito naman yung number 2. Number 2, a person is insolvent within the meaning of this title who either has ceased to pay his debts in the ordinary course of business or cannot pay his debts as they become due, whether insolvency proceedings have been commenced or not. So, yung isang insolvent, hindi siya makabayad. Doesn't matter kung may insolvency proceeding or not. Number 3, goods are in a deliverable state within the meaning of this title when they are in such a state that the buyer would, under contract, be bound to take delivery of them. Yun ang ibig sabihin ng deliverable under this title. Yung tipong pag nakita mo yung goods, susundin mo yung kontrata na tatanggapin ko to kasi ito yung napagkasunduan. Yun ang deliverable. Hindi yung wasak-wasak na yung goods. Article 1637, the provisions of this title are subject to the rules laid down by the mortgage law and the land registration law with regard to immovable property. So maganda in the future, hanapin din natin mortgage law at saka yung land registration law. Okay, ito. Birahin na rin natin yung Title 7. Itong Civil Code na ito kasi napakaikli lang. Title 7 of Book 4 of the Civil Code. Ang kanyang pamagat ay barter or exchange. Article 1638. By the contract of barter or exchange, one of the parties binds himself to give one thing in consideration of the other's promise to give another thing. Bibigay ko sa iyo itong headset ko. Ibibigay mo naman sa akin yung bracelet mo. Yun ang barter. Ito yung uri ng trade na ginagawa nung araw talaga. Yung mga, kung natatandaan nyo yung ating history nung mga bata tayo, di ba? Nakikipag-barter tayo sa mga inchik, di ba? Article 1639, if one of the contracting parties having received the thing promised him in barter should prove that it did not belong to the person who gave it, he cannot be compelled to deliver that which he offered in exchange, but he shall be entitled to damages. Sabi lamang dito, bibigay ko sa iyo itong headset, ibibigay mo sa akin yung bracelet. Yung binigay mo sa akin yung bracelet, hindi naman pala sa iyo. Hindi mo ako pwedeng pilitin na ibigay ko ito sa iyo. Liable ka pa na bayaran ako ng damages. Article 1640, one who loses by eviction the thing received in barter may recover that which he gave in exchange with the right to damages, or he may only demand an indemnity for damages. However, he can only make use of the right to recover the thing which he has delivered while the same remains in the possession of the other party and without prejudice to the rights acquired in good faith in the meantime by a third person. Article 1641, as to all matters not specifically provided for in this title, barter shall be governed by the provisions of the preceding title relating to sales. So magkadikit to, tamang-tama yun. Binasa natin yung sales and barter na magkadikit. Kasi yung mga hindi nabanggit dito, yung barter daw shall be governed by mga rules din o provisions din ng sale. So dyan tayo nagtatapos ngayon. Natapos na natin yung continuation ng Title 6, 'di ba? And ng buong Title 7, which is yung barter. Sana nag-enjoy kayo sa ating pagbabasa ng mga batas ngayon at sana samahan nyo ulit ako na magbasa at subukang ipaliwanag ang mga batas in layman's term. Uh, but first of all, bago ako mag-goodbye, gusto ko lang maghatid ng condolence sa pamilya ng mga Farales sa pagkamatay ni Attorney Sam Farales. Ngayon ko lang nabalitaan ngayong araw na to. Saktong-sakto pa na sales ang binabasa ko, doon ko siya naging teacher. Although wala akong natutunan sa kanya kasi nagkikwento na lang siya ng buhay niya, nag-enjoy ako. Yun yung mga pagkakataong nag-enjoy ako mag-aaral ng law, yung wala akong natututunan. Wala akong natututunan na related dito, pero may natututunan naman ako sa buhay niya. Anyway, condolence po sa pamilya ninyo. And sumalangit nawa ang iyong kaluluwa. God bless sa'yo. And hope na mapunta ka sa maayos na kalagayan. And muli, nais kong magbigay ng mensahe lamang para sa nasalanta ng bagyong Ulysses, no? Nitong nagdaang November 11, 12, 13, lalo na sa mga napanood natin sa Marikina, Rizal, Catanduanes, at iba-iba pang mga lugar na napinsala, na God bless at naway makabangon kayo, kaawaan kayo ng Panginoon. Kaya nga nung nakita ko yung pinsalang yun, naisip ko na wala akong karapatang magreklamo. Kahit na binaharing kami, hindi naman kami pinasok, hindi naman kami nasiraan ng ari-arian ng ganon katindi sa dinanas ninyo. So God bless, at kung mayaman lang ako sayang, marami sana ako matutulong. So God bless sa inyo and good luck, and ayun lamang, keep safe po.